Hello everyone, myself Sajian, Dr.Seema Rathi from School of Law and Legal Studies, Sage University, Bhopal. My today's video lecture is on Discharge of Contract Part 1. It means a contract may be discharged in the following ways. First is by performance of contract, that is defined under section 37 to 67. Next is by breach of contract. It also includes anticipatory breach, that is defined under section 39. Next is by impossibility of performance. It also includes doctrine of frustration, that is defined under section 56. And last one is by agreement and novation, that is defined under section 62 to 67. So these are the ways through which we can discharge the contract. Now, first is discharge by performance. It means in contract, each party to it is bound to perform his part of obligation, and after parties have made due performance of contract, their liability under the contract comes to an end. And in discharge by breach, here duty to perform a contract fails to do that, and performance of contract becomes impossible and refuses to perform the contract. That is known as discharge by breach. Now, on breach of contract by one party, here other party is discharged from his obligation to perform, and other party also gets right to sue the party for breach of contract and damages for loss. Now, breach of contract may be actual, and actual means non-performance of contract on the due date of performance. Now, anticipatory breach. Before the due date of performance has come, it can be done. Now, the example for actual breach is A is to supply certain goods to B on 1st January. On 1st January, A doesn't supply the goods. Here, he has made actual breach. And there is another example that is for anticipatory breach. On the other hand, if A informs B on 1st December that he will not perform the contract on 1st January next, A has made anticipatory breach of contract. Now, section 39 talks about anticipatory breach of contract, which means repudiation of contract by one party to it before the due date of its performance has arrived, either by refusing to perform the contract or disabling himself from performing the contract in its entirety before the due date of performance has arrived. For example, A singer contracts B, the manager of theatre, to sing at his theatre 2 nights in every week during next 2 months. B engages to pay her 100 rupees for each night's performance. On 6th night, A willfully absents herself from theatre. Now B can end the contract. Next is discharge by impossibility of performance. If performance of contract is impossible, that is also known as void contract. It is defined under section 56, which mentions two kinds of impossibility. First is impossibility existing at the time of making the contract, and secondly, the contract which is possible of performance and lawful when made, but the same becomes impossible or unlawful thereafter due to some supervening event. Now, initial impossibility is defined under section 56, para 1. An agreement to do an act impossible in itself is void. If a contract is impossible of being performed party can never fulfill their obligation and such an agreement is void. For example, A agrees with B to discover treasure by magic. It's impossible to perform, so the agreement is void. For example, agreement to bring a dead to life is also void. Now, impossibility here means physical and legal both. Section 23 also declares that every agreement of which the object or consideration is unlawful is void. For example, A contracts to marry B, being already married to C and being forbidden by law, to which he is subject to practice polygamy. Agreement by A to marry B is void. Thank you.